two amazing boys. My youngest son is Elijah. He is 4 years old. And my oldest son is Josiah, and he is 7. And I'm just I'm just your average guy who's gone through the family court system in Texas. It's been a nightmare, and it's been a real eye opener to just what it's like to be discriminated against and to have a lot of your rights and liberties that are guaranteed through the Constitution, to have those kind of freedoms trampled on. And I'm in the fight to see things change, and that's kind of my goal right now. I feel like my whole life is dedicated to that right now, and every aspect of my life. But the short and simple of it is, I have two boys. I love them. I love my kids to death. There's nothing I wouldn't do for them. Um, Kids have always had a special place in my heart, and having two sons. I mean, the moment that I was in the operating room and both my children were born was nothing short of magical. And I've always wanted to be a dad, and I couldn't be more happier. I couldn't be more blessed than I am to have two kids. And I want to have the full effect of that, like any married dad would have. And that's been removed from me. I still have a great time with both my boys, with both Elijah and Josiah. But a lot of us aren't experiencing, and our kids are not experiencing, what it really means to have two parents, to have both parents in their lives. And a lot of dads don't even have what I have, which I have an expanded possession order, and then a few days on top of that. Most of these dads, and yes, there's some moms here in Texas as well, they're visitors to their children. Their children don't get the parenting and the love and the affection in the same way as a married dad or mom has in Texas. So that's just a little bit about my story about my kids.
Okay. All right, Josh. So you and I, we met through the Americans for Parental Equality, because we have a lot of things in common as far as our children being taken away from us, and for no other reason than we're expected to make the money, and somebody has to make the money, and therefore you get less time with the children. And it's a traditional mentality. It goes decades. Believe it or not, 100 years ago, men used to get custody, and then it switched. But so that's where we are now, and that's why you and I know each other. So you, I had started helping you because you were going through the child support enforcement process, um, and you were you were notified of the hearing, and you went to the hearing, and you provided a you provided testimony, and you also had a public defender with you, didn't you?
Yes, I had a
Right.
public defender that was appointed to me.
And
Uh,
we'll be talking about that public defender too. But so you had a public defender. You were found. You applied for indigency, right? And this is kind of funny because they said you were indigent and that you couldn't afford an attorney. So they got you an attorney, and then they were still wanting to see if you could afford to pay child support. It's like, well, wait a minute, you just said I couldn't even afford an attorney. But you want me to you want me to pull all this money out of my pocket.
yeah, hearing some of the stuff that happens, and I look back on it now, and I think they knew I was too poor to have an attorney, and I provided evidence for them. Nobody disagreed that I was too poor to pay an attorney, and yet they wanted me to pay an exorbitant amount of child support payments, even though, and this is on top of me having the children, providing all the transportation and the medical expenses for the children. Which, don't get me wrong, I am not against providing for my children, but there's two parents in this scenario, and if we were married, we would both be equally under the support and care of our children, which we were when their mom and I were married together. But under this scenario, you're laden with all the basically most of the financial responsibility for that, and that's how you're expected to live.
Right. Now, a little bit of, I want to touch on something that you went in and you told them in front of, you told the judge and you got it on the record. You, why don't you tell us a little bit about what you did? What do you recall from what your testimony and how what you addressed the court, what words that you used? Just tell us everything that happened that day that you went to the child support hearing, and they found you in contempt.
Okay, so I showed up for the child support hearing. Now this is a couple months after it got reset. They gave me a public defender, and the judge was very specific. He said, "Call this public defender every day. Get a hold of him. It is your responsibility to get in touch with this public defender." So I thought to myself, great, I've got someone at least that I can talk to, and we can figure out a plan for this. Well, the problem is this: I called this guy every single day, and I never got any response. In fact, I even called the public defender's office and I said, "Man, I have this public defender that the judge has appointed to me, and I can't even get a response. Can I get somebody else? What can I do?" And she said, "Well, just keep calling." So that's what I did. I kept calling over there, and then finally, the day before court, in fact, that afternoon before court, I finally got through to the secretary, and she said, "Well, we'll set up an appointment for this afternoon, I believe it was." And I called back, and I finally was able to speak with him for about I think 25-30 minutes. And my thought was, at the time, I'd already filed a motion to um, I'd already filed a motion to delay the trial until I had an attorney, until I could I filed for a continuance.
Yeah,
Is what
you
it's
filed
called.
for a continuance. Uh-huh.
Yes, yes. So I
I
filed
think
for a
that was the
continuance.
first document we filed.
Yes, yes, it was. I believe it was one of the first documents that we filed was a continuance, and which is standard. I mean, if you're not prepared for court, and I was not prepared. I didn't, I felt like I needed a legal defense, and under the U.S. Constitution, you are to have, if you're being charged with a crime, and you are unable to afford an attorney, which I was not, one will be provided for you, and I hadn't even had anybody to talk to. So the day before the trial, I get to speak to him, and I told him, kind of briefed him, and the first thing that this man said to me was, "Well, they're going to find you in contempt." And I said, "Well, how do you know that?" And he said, "Well, that's what they're going to do." And I said, "Well," and I'd been talking with Andrew, and I said, "Well, why can't I do the affirmative defense, which is the legislature put this language in there so that if you're poor and you cannot afford this for any numerous amount of circumstances, if you fall ill, if you lose your job, if there's any reason like that you can't make the child support payments, or you're not making them in full, it's a way that you will not be put in jail, because our country has laws, and there is no debtor's prison anymore. At least there's not supposed to be."
Well,
But my
let
own
me
public
explain
defender
that.
already told me that I was going to be guilty of this, and that they were going to find me in contempt for not paying, without hearing any facts about my case. Before he heard any testimony from me, my public defender told me point blank, "You are going to be found guilty in contempt."
And the affirmative defense here, that is something that is outlined in Texas law. Each state has one, but they're all different. Texas has the affirmative defense is this. It's 5 parts. Um, you must lack the ability to provide support in the amount ordered. Number 2 is that you must lack property that could be sold, mortgaged, or otherwise pledged to raise the funds needed. Number 3 is attempted unsuccessfully to borrow the funds needed. Number 4 is that you knew of no source from which the money could have been borrowed or legally obtained. So
Yes, and
I'm
I
sorry. There's four of them. I thought there was five. I think there is a fifth one.
well, you were going to
But
speak about the children's best interest.
this right here, yeah, and also everything must apply. Everything that happens must be in the child's best interest, and that it brings up some points where you you it's basically very easy to do this because it's happened in David Smith where he just went up there and told them, I'm having hard times. You guys need to get off my back, and they threw him in jail. And then the appellate court said that he was okay, that he did the right thing. And what they were trying to do is that attorney, he works in a system, man. They all know each other. I've sat there and listened to him in the courthouse, and they're all buddy buddy. They talk shit about the dad when he leaves, and then with the mom, and then when the mom leaves, they talk shit about her. It's awesome. They're just buddy. They're fooling everybody. So he's telling you you're in contempt because they just want to get this shit done. The more people they get
You
through the
know,
system,
the
the better for them.
the the amazing thing was to me that when I talked to the attorney and we were sitting in the courtroom before the hearing, he said, "Oh, I know Judge Durst." He said, "I know him very well. We're good friends." And he said, "I'm going to actually go out and visit with him for a little bit." And so he went up to the bench. The judge wasn't busy with anything at that time, and he was waiting for our hearing to start. And he chit chatted and they laughed together for about 5 minutes. Now, that to me is a huge conflict of interest because this man was supposed to represent me. And if you're friends with a lawyer, or if the lawyer's friends with the judge, and vice versa, they're not going to want to step on each other's toes. Their friendship is going to be more important than the defense of my case. And that's exactly what happened. In fact, when we started the case, the first thing I asked for was for a continuance because my attorney, this man that was appointed to me, still had zero idea of any of the facts of my case, and that actually came out as the trial was going on. He didn't know what questions to ask. He didn't know what not to ask. Um, he really had no idea of my situation or any of the details of it, and that's why I'd asked for a continuance. So I asked for one, and my attorney, the state provided attorney, threw me under the bus and said, "Your Honor, my client thinks we need a continuance, but I'm confident that we can go ahead at this point and that we don't need one. We're going to argue, and I'm prepared to do that." And I interjected again and said, "Your Honor, we are not ready. Uh, he knows nothing of my case. We had a conversation for about 30 minutes the day before and a few minutes out in the hall. We are not ready." And the judge again looked at him and he again said, I'm ready, Your Honor. We can go ahead and proceed." And so that's what they did. They went ahead and proceeded. And that to me right there showed the bias that the lawyer and the judge had going on. He should have never gone against what his client recommended, especially when he had no details, that he had no basis for my case, for knowing anything about my case other than the few minutes that we had discussed over the phone.
Like he
And
doesn't even
just,
know your occupation.
yeah, he didn't even know my occupation. He didn't know what I did. He had no details of anything about that. And to me, it also showed that what he had said before, that this lawyer told me the day before that the judge was going to find me in contempt, even though there was obviously facts for my case that I was unable to pay.
Mm-hmm.
It showed that the lawyer already knew what the judge was going to say, because the judge is going to rule that without hearing any facts and without knowing any details of the case. His mind is already made up what's going to happen before you even step up there.
Yeah, see, how is he supposed to help you plead the affirmative defense if he doesn't even know the answers to these questions? And here's an interesting thing is in 2011, the Supreme Court in Turner versus Rogers, they said that when the states do this child support stuff, they're supposed to find out if they're supposed to send out questionnaires asking for your income and questions to determine whether or not you can actually pay before they even send you a letter that says, come on in because we got to waste taxpayer dollars to have a hearing. And the thing is they're going to make you responsible for that money. Some of these places, when you modify a custody order or enforce it, they end up making you pay the court costs too. And there's a clerk's fee and the court's fee and the transcriber's fee and the office. There's all these fees that they add on to your child support. And they didn't even bother to find out if that was even necessary. They just made you do it. They used the power given to them under the color of law to make you responsible for another bill. Is what they did. And even the Department of Health and Human Services at the federal level, it's in the president's cabinet. Those people also control child support and stuff like that, from the Fed level. Well, those guys at the federal level, they even sent out a memo and that said, "Hey, you guys got to start asking people. Just stop making people come into your courtrooms. You got to start asking people this stuff before you go that far." But they haven't done it. They don't obey Turner versus Rogers. That was 2011, man. That was like 6 years ago. It's ridiculous, man.
Another problem that I had when I was in court was the fact that the state was charging me with two different crimes. One was a civil contempt, and the other was for criminal contempt. Well, for civil contempt, you merely have to prove a preponderance of the evidence, a preponderance of the facts, which that's easy. It's you're using your personal testimony. The level of evidence is relatively low. Now, the second charge of contempt was criminal contempt. And for you to be charged with criminal contempt, you have to have clear and convincing evidence. Now, Haya had introduced a motion into that, and the judge did nothing with that. And even my attorney, it seemed that he didn't understand what was going on with that. And, of course, they charged me with criminal contempt.
Right.
For you to be charged with criminal contempt, you have to have clear and convincing evidence.
Well, no, what they did was in that order. I saw your order. They tried to hide criminal punishment disguised as civil rules, and for civil contempt, because there's two types. Civil contempt is what they're doing when you have the ability to pay and you got to go in and do this affirmative defense thing. But it's less time. It's like 180 days. But however, if you don't have any way of paying, they can't throw you in there, and they have to know that you have money. Somebody has to prove that you have the ability to pay. Or you have to be dumb enough to go like, yeah, I've got like $10 million, but I ain't giving you the damn thing. Well, then they can throw you in jail until you pay. But if you can't, they can't throw you in jail. That's just how it is. They have to do it. Now, for criminal, though, at the criminal level, the state is responsible for proving. They have to prove that you have the ability to pay, not you having to prove. It's kind of confusing, but in this case, they're making you do the whole thing, but they're punishing you more, and they're not supposed to. They're high. It is so like despicable what they're doing, and that's Hicks versus Fayok. It's a case out of California that determined that, and I mean, you went in there and properly. You even filed a motion for special exemptions, to asking them to identify, is this criminal or civil. Somebody, we need to pull the reins, press on the brakes, and identify, is this going to be a civil case or a criminal case, because the level of evidence is different. And you guys are trying to make it at the least one, where it's the easiest on you in the civil, because it's just a preponderance of evidence. But then when you're the only one providing any evidence of your income, and the other side is like, yeah, we don't have any evidence, how do they win? I mean, even the preponderance of evidence. How do you win with nothing? And that's what child support court. Hey, that's a good title. How do you win with nothing? The story of Title 4D. Because
Yeah.
that's what they do, man. So, and you were trying to do that. You filed the motion for special exemptions, and they just didn't even. Man, you went in. You had to go in there, but luckily you were prepared, and you told them some pretty good testimony.
But the fact of the matter is, I did go in there. I did everything right. I proved my case certainly beyond clear and convincing evidence. And yet they still went ahead and they were going to throw me in jail. And I'll tell you what, there is no recourse for anybody going through these courts. The thing is, they don't care. You can either appeal it or not. That's your business. But they've made the Title 4D money, and that's all they care about. They don't care whether they're throwing people in jail.
Or
They
taking their
don't care
children.
whether, yes, they don't care. None of that matters to them, because the sole responsibility of that courtroom is to take as much money as they can get. And it says it in the family code that they are to maximize the amount of child support and Title 4D incentives. They're to get the maximum amount. The way they do that
Yeah,
is
yeah.
by
So real
filing
quick, that's
enforcement.
that's section 201.107 state and federal funds, and that's in the family code in judicial resources and services, chapter 201, the associate judge. There's two parts. There's an A and a B. I mean, A, B, and C. I believe there's C, but it's in the B section regarding judges that preside over child support hearings. And you're right. 201.107, it says, let's see. Oh, wait, what was it again? It's here in B, sorry. 107. Here we go. State and federal funds. The Office of Court Administration shall contract with the Title 4D agency for available state and federal funds under Title 4D. Now, there's some more stuff in there, but basically the one you're referring to says this: the presiding judges and the Title 4D agency shall act and are authorized to take any action necessary to maximize the amount of federal funds available under the Title 4D program. Even
How
the law freaking tells them to
how
violate the law, man.
how is that not a conflict of interest? Telling the
Exactly.
judge to find you guilty whether there's evidence or not. That's basically what it's telling the judge to do. Maximize the amount. That's why I say when I went up there, they wouldn't take any evidence from me. They wouldn't take any paperwork from me. They wouldn't take anything, any pictures, nothing. They didn't even want to hear testimony that I gave about my children and how much time I spent with them. They shut me down. They said, "Okay, no, change the subject. That's not pertinent to our that's not relevant to this case." Because they honestly don't care. Their goal is not to have a court there and to decide on the facts of the case. Their goal is to make a ruling so that they can get as much federal incentives from the ruling as they can. And they're instructed to do so by our state code.
That's right.
That's some good stuff right there, though,
Do
man.
you
When
do you
when it
know when
tells the judge right there, you know,
all this stuff, man, all this stuff written back in 1995, man, all of
uh,
it, like it was, man. There's so much of it that was written back in 1995. Like,
was,
said the
was it
custody laws is 50%. No, the custody laws are 50% of them were written back in 1995, and then some new stuff has been added to it. But the child support stuff, it's like 75% new stuff. It's just, it's all new because they've been modifying it so that they can squeeze out more money, bending the rules. I spoke to the guy who wrote these laws, who built this system. I've talked to the Wizard of Oz, man. The Wizard of Oz, I've spoken to him. And he told me back in those days, he tried to get 50-50, but the Supreme Court of Texas wasn't having it. And I assume that meant that the Supreme Court of Texas had told him, no, that's not gonna happen. You're not gonna get equal custody. So maybe it goes all the way up to the Supreme Court of Texas, the civil part, because there's a criminal section for it as well, but we never have to deal with it. And this is all civil, so Supreme Court of Texas. So I mean, and then he said that there was like a 60-40, but then he got a lot of flack from different counties in Texas. And then he came up with this standard possession, this like 1585 and possession ratio. And everybody loved it, and they're like, all right, fine, we'll just take that, So he said he really didn't have a choice, but then he also said that judges rubber stamp shit because they don't want to litigate, and they'll tell attorneys, this is how it's going to be. Like your attorney and the judge had already said, hey, this is how we're going to do it. I'm just going to find him in contempt. And the attorney was like, yeah, all right, what's up? All right, we'll see you on Sunday, though. Don't forget to bring the potato salad. So, he went out there and told you, yeah, the judge is going to find you in contempt, man. We're ready. Yeah, he's guilty. Your Honor, my client is guilty. That was what's gonna happen, man. That's pretty much what did happen. But the Oz man, the wizard, he said that he said some things that made me think that he wasn't all that bad, but then I've heard about him before. And just like the Wizard of Oz, people have a bad outlook on him. But I don't know. I think there might be more to it. So, but I haven't spoken to him for a couple of weeks now. But yeah, man, you were ready, dude. You had the affirmative defense. You even challenged to clear. You even in motioned to clarify what kind of burden of proof are we talking about here? Are we talking about preponderance or clear and convincing? And you guys want preponderance, but you still you don't have anything. Like, how's this working out? But they bend the rules, man, because they know that if they throw you in jail, someone's going to pay. You're going to have a family member to get you out, and they keep that money. Or you're going to find money somewhere, or you'll just stay in jail, and then, they write it off or whatever. They take that chance because it's not their money. It's our money. And it's, the government doesn't care. They'll spend it. But see, these associate judges, man, they get picked by a presiding, by an administrative judge. That judge gets appointed by the governor of Texas. And the administrative judge, he comes up with a group of judges, and he says, okay, and he goes down to the district and the county court at law judges and says, here you go. You can pick a judge from one of these 20 guys, or two, or one, doesn't matter. So then the district or county judges, they're like, all right, I'll take so-and-so. So they hire so-and-so to be a judge, but he presides over Title 4D child support cases. So the law clearly says that you were hired to maximize Title 4D funding. So you do whatever it takes to maximize it. That's all you're there for. And if you don't do it, we can grade your performance, and you can stay here for 4 years and you'll never come back if you don't perform. If you don't make the numbers, then we'll get somebody else to do it. But you got 4 years. Or they can get rid of the judge through like a panel, and you're gone. So if you're not going after that money, and you're trying to, if you have more cases and not enough results like enforcements or, money coming in, you look bad and you could get fired. That's your job. So, man, it's a total conflict of interest. Total.
I'm just thinking. Everybody is surprised that these courts don't take evidence. And I don't know how many people have been to a Title 4D judge court. They've been in a Title 4D judge before them. I have been there twice now. And when I wanted to present evidence and I had it in my hand and I wanted to enter it, the judge said, the first time one judge told me, he said, no, I don't take any evidence here. I just make rulings. If you want to try to get something else, he said you'll have to file a de novo hearing with the presiding judge. Well, the second time here, when I went before the judge again, I tried to enter evidence, and they said, no, we don't take evidence in here. We don't take any paperwork or anything. So it's basically just oral testimony that you're giving.
Yeah, that's it, man. And that's what worked for David Smith and Donna Anderson. And they were released from custody using a writ of habeas corpus because the judges abused their discretion. And everything that you did matched those two cases. So the judge abused his discretion.
I even brought up the case of Donna Anderson and how it mirrors mine really closely. And I don't know if again, I don't think these judges are listening to any of the evidence. I think they've already made up their mind to maximize the amount of child support. They're going to rule contempt every time. I don't think that they have any other option because that's what the state tells them to do. So my question is, why are we even going to court and having a hearing? If it's already been decided that they're going to find you guilty, what's the purpose of having a hearing? Well, why don't they just send you paperwork that says you're in contempt? If there's not going to be a trial, if there's going to be no due process, let's just skip it. Let's not even go to court. Let's save everybody a day of going to court and sitting in a room for 3 or 4 hours, and just go ahead and tell everybody if you don't make your payments and you're in contempt and you're going to jail. Well, you know what? That'd be a little too obvious, and we don't have debtors' prisons in the U.S. anymore. So this is just a little camouflage. We put a little lipstick on the pig. We tell everybody, come on in. We're going to hear some justice. Let's hear your side of the story. Okay, are we all done? Okay, contempt. And that's what you get. There is no due process in any of these state courts. And it's not just in my local court here, in my county courthouse. This happens all across Texas.
All across the country, man. It's all across the country.
You know, Andrew, as I look back on it now, I thought that going into court, sharing my side of the story, showing the evidence, I didn't think there was any question in my mind that if the judge were to rule fair, if he would listen to the evidence and look at what the Court of Appeals has done with a similar case, with two similar cases, if he would listen and be fair and just, I felt like there should have been some leeway. And that was my problem. If you go into these courts, you can't expect them to be just. Again, the state tells these judges to maximize the amount that they get through the Title 4D. And so when you have that directive from our state codes that tells the judges to do this, they are going to rule in contempt every time because that's how they get the money. Number one, they get it for the enforcement. But number two, it also puts you on edge that you are going to try to find any way that you possibly can to pay for that, whether it might be through borrowing, might be through getting friends to help you out, anything that you can possibly do. You're going to go into debt to try to make those payments because you don't want to go to jail. Again, all this action, all it does is create more federal money and more federal incentives so that these judges can collect. And that's what the name of the game is. It's to get as much money as you can. And in return, they don't care whether you are homeless. They don't care whether your kids don't see you for several months. They don't care. They don't care if you have debt. In fact, the judge looked at me and said, I really don't care. You're going to have to find some way to pay. It doesn't matter. You need to come up with the money.
They say it's under the pretense of the best interest of the child, but they're like they have no reservations about taking, people away from their children. They don't. It's like that right there has to be the worst thing. You know what I mean? And I know they're trying to get money out of people, but they're definitely going about it the wrong way. They're picking on poor people, man. They would never, you would never do it to a rich person because they're, man, well, they don't need to be in child support anyway. They're probably taking care of their kids. But in the event that these people have money and they don't take care of their kids and they have all this money, yeah, okay, something's something should be done about that. But I mean, they're going after poor people, you know,
You
people
know,
that make a
it,
living like week to week or day to day. I mean, and they don't care about that stuff. They're just like whatever, we'll squeeze you.
and here's the crazy thing about this case. When the judge finally made his orders and checked everything off, there's a checkbox that says this is in the best interest of the children. That box is checked off. But I'm going to tell you something. When I was there in that courtroom, nobody brought anything up about what was best for my children other than me. And when I did bring up what was best for the children, and I explained to them, look, this is going to hurt the children to have their father taken away. When I described that to the court, they didn't want to hear any more testimony, and they said that is not relevant to the case. Well, how could that not be relevant to the case?
It's in the best interest of the child is the ultimate factor in these cases. It's the ultimate factor. That's Hicks versus Fayok too. I mean, it's the ultimate factor. They and then and it says it on their order that they're addressing the best interest. It's the last one. It's like the last one. Somebody put it there intentionally for the judge to be like, okay, is this in the best interest? He's just like, I never liked that one, but I'm gonna check it off. I hate that one. I hate that one, but I'm gonna check it off anyway. Oh man, they do that. Oh, because they don't want to hear your sob story. They don't want to know you're a human. You're just a number.
Well, and I think it affects them when they hear that they're doing this, and hear they're ordered to maximize the child support.
Yeah. Well, they're just trying to keep their job. You know what I mean? That's their job. But we'll see if we can't shut them down, man. Because there's all this stuff that's coming out is starting to identify the contradictory relationship between the judges and the incentives and their resulting effect on the American family structure. So you went in there and you met the affirmative defense. You told them you were in construction, that it's a volatile profession. I mean, you got costs. You have multiple roles. You're marketing, your sales, your customer service. You're performing the construction. You're in engineering. You're doing all this stuff, man. And it's taxing. Plus, you got to take time with your kids. I mean, you're doing the best you can. You're not an alcoholic. You don't do anything, man. I believe you go to a church. I mean, you're just being a dad, and you went in there and told them that, and basically so that you would meet the requirements of the affirmative defense, and they didn't want to hear it. They like didn't even follow their own rules, and to really pour salt on the wound, they didn't even have any evidence. They didn't even prove your ability to pay. They
It,
had no evidence, yet they won, and you were found in contempt. But it was postponed until today or yesterday, as a matter of fact. I think it was so, or Monday. It was postponed until this past Monday, and so we had tried an appeal, and the appeal was going to identify the contradictory relationship between them and the fact that you had identified the affirmative defense properly, that they had provided no um, no evidence whatsoever that they denied your ability to testify as identified in Bearden versus Georgia. And they wouldn't even hear you when you wanted to talk about your kids. And the whole reason you were there is for your kids. If it wasn't for those kids, you wouldn't be there. They wouldn't be there. So, it's kind of like, what? Unfortunately, the appeal, we missed a crucial part of the appeal on getting the judge his findings of facts, because findings of facts are really complicated. It's not just a request. You're actually giving you're actually paraphrasing and giving it back to the judge to sign off on. They don't actually write anything. You're just paraphrasing, and just real quick on that, um either party can write a findings of facts that is in their favor. So you can write a finding. You were gonna have to write a findings of facts that said that got the judge to say that he didn't consider certain things, and that your affirmative defense, although proper, didn't meet his level of discretion. Something to like just bait him into it. That's one of the tactics of that. But I mean, we missed it. We missed that, and then your only recourse right now that you know of was the federal removal. And I mean, you waited you were freaking out when we missed the appeal deadline. So you were freaking out about that and didn't know what to do. And
Well,
the federal
the
removal
simple
just kind of happened to find you.
the simple fact of the matter was, I was never going to find justice in that courtroom. The Title 4D judge was not going to give me any justice, and the presiding judge was not going to give me any justice. And you know what? Did I have any faith that the appeals court would have done something? They could have. They might have left me in there in jail. I don't know. But I can tell you this, I didn't have very much confidence that the state court would do anything for me either in the Court of Appeals. And I'm limited on time, I'm limited on resources. So that's why I filed the federal removal. I felt like my back was up against the wall. I need somebody. I need somebody to help me out with this. And the state is biased against me. I mean, they're the ones who have written these rules that have helped these judges get away with this stuff. So at this point, I removed to federal court so that I could find another fight. That I could fight this another way. And it's obvious that the state is biased against this. I'm asking the federal government to step in, to look at these laws, and to make a ruling.
Yeah. I mean, and chances are you got a federal judge who used to be a state judge, so he knows his friends there, you know what I mean? And that's going to be that's also something else that makes the removal like anything else. Any of these other remedies, there's a ton of remedies, and the federal removal is just one of them, and it has its risks too. It's not a you know, it's not a cure. It's just another way of attacking these issues. And it's going through the federal level. So when you got a judge that's part of the gang and he's in the feds, well, guess what? He's part of the gang. You're gonna have some problems there. So you'll probably, you're gonna have to appeal to the circuit out in Louisiana. But
That's the problem. We've got rights in our country, and these courts are supposed to protect us. They're supposed to look out and they're supposed to defend us and they're supposed to protect our rights, and they're not doing it. I can tell you right now, these state courts are about the most corrupt as you can possibly imagine. Now, I hope to get something better out of the federal courts. But again, like you said, a lot of these federal judges come from the state. They've got friends. And the system that we're looking at overthrowing right now, is a multi-billion-dollar industry. There is hundreds of billions of dollars that are being exchanged over this every year. The lawyers are making money. The judges are making money. The prisons are making money. Everybody's making money off this. And for this to be upset, for this apple cart, so to speak, to be upset, it's going to affect a lot of people. It's going to upset a lot of people. But I'll tell you, the only people that there is going to be a group of people that's happy with this, and that's going to be the kids. As this here is a cash for kids scheme, and the lives of our kids are being traded for cash, and that is not right. And that's why I filed for a federal removal. I did it for my children. This is about them. This is about the future of Texas. This is about the future of children across our country. We don't want this system here anymore. We want change. And I'm hoping to get justice in the federal government and that they'll rule that some of these laws and statutes that we have in Texas here are clearly unconstitutional.